I guess, spent a lockdown. And I think, I mean, once the first wave was off, I guess it was quite brutal initially.
Yeah, no, it was beautiful. Like I live in the center, so I had the city all to myself because you weren't allowed to enter even from different cities in Italy for quite a long time. So.
Okay. Greetings to everyone present. My name is Ankit Malhotra. I am the co-founder and president of the Jindal Society of International Law. Today amongst us, we have a super speaker who will be talking about an extremely interesting topic. We're also joined by faculty members of the society and also of the university, of the law school more specifically. But before I introduce everyone, let me speak a few words about the Center for Human Studies, under which the society is created. The Center for Human Studies aims to develop a learning platform on opportunities and limits of the United Nations by enhancing research and building knowledge on how the United Nations systems work, both in terms of institutional development and in terms of promotion and implementation of various multilateral policies. The center fits well with the global vision and aspirations of the law school and the university writ large. Often in my discussions with Professor Popovski, he's often recounted the discussion which took place in 1953 when the first Secretary General of the United Nations, Trigger Lee, welcomed Dag Hammarskjöld, his successor in New York. He said, and I quote, "Welcome, Dag, to the most impossible job on this earth," end quote. The UN has been often cited and considered as the scapegoat, and states have failed to live up to its expectations and the living values of the United Nations. But let us also remind ourselves that Hammarskjöld famously said, as perhaps a response, that the United Nations was created not to take us to heaven, but to save us from hell. The Center for the UN Studies engages in these sorts of projects, studying the history and traditions of the United Nations and of society at large. It is also engaged in approaches of studying approaches and researches of international law, teachings and societal engagements, and having in mind the latest dynamic geopolitical technological trends. The Society of International Law is an initiative under the aegis of the Center for Human Studies and is run under the expert guidance and tutelage of Professor Dr. Weston Popovski. Founded in 2020, the Society is created to provide a platform to young students and enthusiasts of international law. The Society was launched on November 18, 2020 by a special guest lecture and inaugural lecture by Herbert and Rose Rubin Professor of International Law, Jose Enrique Alvarez of NYU. He was joined in the panel by our respected Vice Chancellor, Professor Dr. Rajkumar, the faculty coordinator and vice dean of the law school, Professor Dr. Weston Popovski, and a very dear friend of the society, Professor Dr. Mohan Kumar. Our fall lecture series of 2021 explores the ecosystem of international law and builds upon the introduction given on internationalism and international law by the concluded spring lecture series titled Future of Internationalism and International Law. The fall lecture series endeavors to study the different contours of international law. To assist in this study, the speakers will cover and address the respective areas of expertise based upon their years of research and practice. Given the vast ecosystem and engagement of international law in it, the Society aims to study the fragmentation and fertilization of the various disciplines in this ecosystem. The lowest common denominator in the fall lecture series is to enhance and provide a deeper understanding of international law through international lawyers. The Society for its members has a well of knowledge and a quorum of thought-provoking discussions, which will be the resultant of its engagements with experts aimed at exploring this very ecosystem of international law. To talk on the topic or share her thoughts on the topic of nationality and belonging in international law, we have amongst us Professor Dr. Neha Jain, who is a professor of public international law and co-director of the Academy of European Law at the European University Institute. She is on special leave from her position as associate professor at the University of Minnesota Law. Jain's scholarship focuses on public international law, human rights, criminal law, and comparative law. She is the author of Perpetrators and Accessories in International Criminal Law, and her work has appeared in numerous journals, including the American Journal of Comparative Law, American Journal of International Law, the European Journal of International Law, and Harvard International Law Journal. I welcome Professor Jain, and I also welcome Professors Harshit Yadav and Marilyn, who will be joining her as commentators and as dear faculty advisors and respected seniors of this society. Ma'am, thank you so much for accepting our invite, and the floor is yours.
Great, thanks very much. Thanks very much for inviting me. And I wish we could have done this in person, but I'm excited that we at least get to be together virtually to just share some thoughts about this topic, which is actually a new one for me. So I'm also particularly grateful for Professors Yadav and also to Professor Marilyn for taking the time to engage in this conversation, because that's one of the most exciting things about academia, that you get to talk about things you care about with interesting people. So all good ideas, all good papers, all good theses begin with a story. So I too wanted to begin today with a story. For those of you who are Kafka fans, and most lawyers happen to be Kafka fans, paradoxically, in the trial, Kafka introduces a parable called Before the Law. So before the law sits a gatekeeper, and to this gatekeeper comes a man from the country, and he's trying to seek entry into the gates of the law. But the doorkeeper tells him he can't go through, at least not just now. He can try and force his way in, but he'll do so at his peril. And so the man's a bit taken aback because he assumed that the gates of the law are open and accessible to everyone. But he decides to wait till he gets permission to go inside. The gatekeeper looks quite intimidating. And so he waits for years on years. He bears with the gatekeeper's interrogations. He tries to bribe him to gain access to the gates of the law. He even asks the fleas that have settled on the gatekeeper's fur collar to help him try and persuade the gatekeeper to let him through. But nothing works. And finally, as the years pass, and as he's about to die, he sees the light grow dim, and he asks the gatekeeper that even though everyone strives after the law, in all the years that he stood waiting outside its gates, how come no one else, he's seen no one else try and gain entry through these gates? No one else has requested entry. And the gatekeeper answers, here, no one else can gain entry because this entrance was assigned only to you. And as you die, I'm now going to close it. And in the time I have for my talk, I want to draw an analogy between this man from the country and the predicament of this stateless person, an individual who tries to seek entry into the gates of citizenship, to find that his entry is barred by a series of legal gatekeepers, each one stronger than the next, more powerful than the next, and who's kept waiting in a limbo zone between citizenship and alienness, only to discover at the very end that the gate through which he was trying so desperately to enter is not a universal portal through which everyone must pass, but rather a gate that's meant to deter the unfortunate few who the state wishes to exclude from political membership. And so my main argument is that this kind of statelessness is not necessarily the result of technical problems, such as a conflict in nationality laws, nor is it caused by seismic events, such as state dismemberment, and neither is it a collateral consequence of state ineptitude, so simple bureaucracy and inability to manage. Rather, I see statelessness as statecraft, it is the state's intentional production of statelessness that I'm interested in, and the way in which this statelessness takes place under the shadow of the law. And my aim is to draw the attention of international legal actors to this very strategic production of statelessness, and then to counter efforts at its legitimation. So I'd like to first set the scene for our conversation by walking you very briefly through where the international law discourse on statelessness stands today. Then I will expose how this discourse actually misdiagnoses the causes of statelessness, because it underestimates the state's capacity to manipulate neutral criteria for political membership. And finally, I'll argue that the international legal community needs a new legal roadmap to achieve its ambition to end statelessness, and explore some possibilities together with you for what this roadmap might look like. So let's begin. The phenomenon of statelessness is paradoxically linked to the rise and consolidation of the nation state as the predominant form of political organization. If you lived in an international world in which the whole political order was not defined and divided into self-contained sovereign authorities represented by states, then it wasn't a problem if you didn't have one of these nationalities. But the end of the First World War saw a rise in the number of claims before domestic courts from individuals who were trying to be declared stateless, in fact, because they wanted to avoid the penalties that were associated with their designation as enemy aliens during the war. So for instance, if you were a German enemy alien, then your property could be expropriated in the UK after the First World War. And so you didn't actually want to be declared a German enemy alien, you would rather be declared stateless. In parallel, states were being confronted with refugee flows from the collapse of the Habsburg Empire and the mass denationalization of Russians who were labeled as enemies of the Bolshevik Revolution. And something needed to be done about this increasing number of stateless persons, those who didn't want to be declared as enemy aliens and those who faced mass denationalization, because their presence challenged the ever sharper boundaries that states were beginning to draw between those who were their citizens versus those who were not. This period also coincided with the rise of the welfare state. And again, for the welfare state to actually function, the states needed to be drawing clearer boundaries between those who were entitled to the benefits of this welfare state system and those who were outside the benefits. And then some entity needed to assume responsibilities for these great crashers in the backyards of other states. The entity that was tasked for preventing the threat to the stability of the post-war international order was the League of Nations. The League wasn't exactly happy about this assumption of responsibility. And so it pressed for a technical legal solution to statelessness. It said that the problem, why statelessness had arisen, was because of a conflict of nationality laws. The fact that different states had different rules and different regulations for who became a citizen, who could apply for citizenship, and then also for denationalization and withdrawal of nationality. So the problem of statelessness would be overcome if we could just harmonize this diversity in the conditions for naturalization in the national legal systems. The outcome of these efforts were a series of international instruments on the codification of nationality laws, which, whatever they might have achieved with respect to harmonization, did very little to tackle the actual problem of statelessness. We then saw a second attempt to address statelessness, which gathered steam in the wake of the Second World War. And this was because of another form of displacement, mass displacement, this time in the form of mass refugee flows. Indeed, it is the coincidence of these two phenomena, the stateless as well as mass refugee flows, that torpedoed efforts to craft an independent international solution for the problem of statelessness. So you have a number of international legal instruments, again, drafted during this period, that reinforce the notion that the categories of refugees and stateless people overlap in large part. And they also treat non-refugee stateless people as a much smaller percentage of individuals whose conditions are in any case not quite as miserable as those of refugees. And we see the emergence of a bifurcated international law regime that emerges to regulate the conditions of the dispossessed and which prioritizes the protection of refugee populations. So we have the Refugee Convention, which gathers a lot of support amongst member states. We see the creation of the UNHCR as the supervisory body for the convention's implementation. Whereas in contrast, the statelessness conventions that are deliberately drafted to avoid overlaps with the refugee conventions, and which adopt a very narrow definition of statelessness in order to avoid this overlap, struggle to attract signatories. And then finally, in terms of the historical overview, a third attempt to regulate statelessness comes from what some have called the new international law of citizenship, which is the increasingly aggressive stance that international law is beginning to take in challenging state control over decisions related to nationality, including nationality acquisition and withdrawal. And in the context of statelessness, the most significant efforts that we see relate to greater international scrutiny of state measures that relate to restrictions on the acquisition of nationality. But as I discuss in the paper, there's quite a lot of diversity on how the different human rights regimes choose to frame the issue, which is typically contingent on the very narrow focus of the regime itself. For instance, you have a number of instruments, both regional and international, which deal with state succession. So what happens to nationality when you have state succession? Or in some cases, they focused on the specific facts of the alleged case of statelessness rather than zooming out and actually saying something more general. And the regimes themselves contain quite a few ambiguities and loopholes. And in all cases, they leave quite a lot to state discretion. The upshot of this whistle-stop historical tour of international law attempts to regulate statelessness is that international law institutions and actors have tended to view statelessness through the lens of state interests. They've been quite wary of trespassing into the sovereign space, and so they've variously sought to frame statelessness either as a technical legal problem that one can address through avoiding conflicts in nationality laws, as something that's secondary to the much more important problem of refugee populations, or the very fact-specific evaluation that is directed towards preventing the loss of nationality in situations that are overtly discriminatory. And even this more aggressive posture that international and also regional bodies have recently begun to take to tackle statelessness is based on false premises. Because international law assumes that statelessness is either the product of incompetence or oversight on the part of the state, or conversely, that it's a product of manifest illegality. And what I want to argue instead is that statelessness flows from the deliberate exercise of state power. So it is in fact a product of illegality, but that this illegality is not manifest. So the power does not take the shape of explicitly discriminatory laws involving mass denationalization, like in the case of Nazi Germany, but rather states use very shrewd legal techniques and fictions to manufacture statelessness. And they do this not by explicitly declaring that you're not allowed to be in this country if you happen to belong to a certain ethnicity or a certain religion, but they tamper with neutral criteria that are relevant to nationality and to its absence, which is space, time, and documents. And so what do these legal techniques look like? Let me first begin with space. The modern nation state is premised on the notion of fixed territorial borders. So fixed in both time and in place. If you were to close your eyes and imagine a border for now, for instance, the image that probably comes to your mind is that of a fixed line on a map, or a fortification, an actual physical fortification, that cleanly demarcates the exclusive domains of territorially circumscribed sovereignty. But in reality, state boundaries are anything but fixed and stable, because a border is not just a physical construct, but also a legal construct that's both portable and porous, and that the state can continually make and unmake to allocate, distribute, and rescind political membership. And in the paper, I discussed different ways in which the state reinvents its territorial border through the words of the law in order to exclude individuals from entitlement to citizenship and to render them stateless. And in exceptional cases, the state may even resort to a sort of self-suicide of excising parts of its own territory in order to create non-state spaces that are then inhabited by islands of putative citizens who now can't claim the nationality of any state. And I'd be happy to talk through any of these techniques in the conversation that follows, and also the specific examples that I give in the paper. But in the interest of time, let me just give you one example of this spatial manipulation and the consequent statelessness. And that's the case of the Bidoon, literally those without nationality, of Kuwait, a group that has fallen victim to a hyper-territorialized and hyper-localized delineation of the boundaries of Kuwaiti membership. It all begins with the 1959 Kuwaiti nationality laws, which base national membership on the concept of a settled population. So entitlement to automatic citizenship was limited to individuals who could prove uninterrupted residence within the walls of the old town and the surrounding oases. The initial beneficiaries of Kuwaiti citizenship were thus an eclectic mix of settled town dwellers, who were known as the Hadar, in contrast to the Bidoon, who were the desert dwellers. And though the Bidoon belonged to tribes that had settled within the territorial limits of Kuwait, the Kuwaiti desert, they did not live within the town walls, and they were not a settled population, and were thus excluded from this very urban concept of Kuwaiti citizenship. And this is the geographic and mental map of citizenship that continues to influence the perception of the Bedouin as a nomadic, stateless people who are now internal others within Kuwait itself. But state boundaries, of course, are not just inscribed in space, but also in time. In fact, the original meaning of the word deadline also plays with this notion of space and time, because the original meaning of the word deadline was in fact not meant to refer to time, but to space. The idea was that if you stepped outside, people in prisons during the American Civil War, if they stepped outside a certain boundary of the prison complex, then they could be shot. And so the idea was that forms, it was literally a difference between life and death, hence a deadline. And the nation state has both in terms of the demarcating criteria. It has space, as I've just discussed, but also time. In fact, it's an exceptional container of time because the nation state governs through temporal devices. Some of these are more familiar to us, like censuses and qualification periods for pretty much everything, which includes the criteria for citizenship. But the time through which the state governs is not scientific time, so the ostensibly neutral and universal time of clocks and calendars, but rather political time. That is the way in which the state marks, measures, and assigns political value to units of chronological time. And this political time is then used to carve out sovereign boundaries around citizenries as a means for measuring qualitative attributes of citizens and for political exchange value, through which amounts of time are demanded of individuals in exchange for rights. And again, unlike other criteria for citizenship, such as language requirements, for instance, or tests that ask you to demonstrate your loyalty to the state, time is normally considered fairly neutral. You have to live in a state for a particular time in order to qualify for citizenship. And most people don't seem to suggest that that's a particularly problematic criteria. But in the article, I discuss how the state can actually suspend or contract or expand or accelerate chronological time, the actual scientific time, and through that, give itself the superpower to create and erase political membership through techniques such as temporal erasure, where you enact and interpret legal concepts to erase the physical time for which an individual has lived within the boundaries of the state. Again, in the paper, I give quite a lot of examples of when the state does this, but to, again, just give one instance here. And this is this de facto statelessness of individuals who find themselves in a condition of state-engineered precariousness, which is the example of the kafala system in the UAE. And this is the guest worker program of the UAE, which brings temporary contractual laborers to the country. And the idea is that they meet short-term labor demands. And while these laborers are not eligible to apply for permanent residence or citizenship, in practice, their residency is constantly extended through short-term labor contracts that are renewed by domestic sponsors. And this has created a class of non-citizen residents who've been settled in the UAE for several generations, while formerly being considered temporary guests by the UAE, who can be deported as and when the UAE wishes. And finally, and this is the last criteria that I want to talk about, as much as being a citizen of somewhere, anywhere, is a matter of meeting the criteria for citizenship, such as time, residence in the physical territory. Fulfilling these conditions counts for very little if you don't have the means to prove it. The citizenship law of modern states demands that you can give an account of your standing in the nation in the form of evidence that the state considers legitimate. If you're without documentation, you do not exist in the eyes of the nation. Or in other words, you're stateless. Citizenship that emerges through the law, its institutions, and forensic documentation, so-called administrative citizenship, can be a highly exclusionary institution and can render stateless already marginalized groups in society. And here I use an example of which you probably know significantly more than I do, given the length of time I've been away from India. One of the most ambitious attempts at the weaponization of documentary citizenship is the effort to enumerate and comprehensively document the population of Assam through the implementation of the National Register for Citizens. And in this, I would probably be rehearsing things that you already know, but just in case you haven't been following. The NRC, of course, has a very long and tortured history in India. It's been buffeted by waves of migration across the border between India and Bangladesh. And ostensibly, it's a highly legalistic exercise to try and identify Indian citizens and weed out illegal immigrants. And so in order to claim citizenship, individuals have to submit legacy data, such as documentary proof that their names were included in the first ever census conducted in independent India in 1951, or they have to give documentary proof of family links to ancestors who were included in the legacy data. Now, of course, requiring documentary proof of residence or family ties stretching back several decades ignores the reality of documentation practices in a country like India, where a significant percentage of the population, as you know and as I know, lives its life bereft of any state-produced identity. It also ignores the geography of Assam, of course, where property and documents are regularly lost to natural disasters, such as floods, land erosion. And even those who miraculously possess these documents have found themselves excluded from the final register due to clerical errors, because you have manual transcribing, recording, and translation of the original documents. And according to some studies, roughly 5% of those with even the correct documents could have been excluded from citizenship due to something as minor as a spelling error. And so the question is, how is international law supposed to respond to these state-manufactured situations of statelessness? And my response is that a promising start would be to stop misdiagnosing the problem. Because international law assumes that statelessness is produced using traditional suspect categories of discrimination, such as race or religion or ethnic origin. And what I argue instead is that statelessness as statecraft does not come breathing fire and brimstone, but rather it follows liberal strategies of exclusion. Sophisticated legal concepts, interpretations, and practices that tamper with what we would normally consider universal and impartial criteria for political exclusion, give the state a carte blanche to exclude without running up against international law norms that constrain statelessness. And as Kafka's Countryman naively assumes, theoretically, these legal tools are equally applicable to any individual who wants to gain entry into the gates of citizenship. Because quantitative temporal measures, just clocks and calendars, don't exhibit an independent bias. But what I hope I've shown is that the effects of legal configurations of time and space and the requirements for documentary citizenship are not randomly distributed. Rather, they reflect pre-existing and extra-legal exclusions of certain types of people from the political imaginary of the nation state. The ultimate result is thus often the same: statelessness that's caused by state-sponsored discrimination and inequality, but it's implemented through facially neutral instruments. And the constraints to the shaping and targeting of statelessness are not found in international law, but in the limits of the state's own legal imagination. And this means that international law needs a new strategic plan on statelessness. And in the article, I gesture at some concrete policy measures that will need to be rethought, such as the UNHCR's emphasis on national identification documentation. But as I discuss in the article, the drive to document and enumerate populations can have the paradoxical effect of rendering stateless people who fall out of the state's categories of citizens versus foreigners. And the UNHCR's emphasis on the ascription of a specific status and the accompanying identity document to an individual without regard to the politics of documentation may have the unintended consequence of increasing rather than eliminating statelessness. And so just to conclude, I have argued that the international community's reports of the potential demise of statelessness, the UNHCR had a campaign where it plans to end statelessness in a decade. These potential plans and the fact that statelessness may go away very soon are greatly exaggerated. At least if this demise is expected to come about through the current international legal efforts that we have in place to tackle statelessness. Statelessness is not vanishing. What it is doing is going underground. And what I hope I've done is give give international law some of the conceptual tools to crack the slippery legal code that helps produce and sustain statelessness. So I very much look forward to your comments, to your questions, any feedback, and thank you again.
Well, thank you, Professor. That was quite a riveting talk and a wholesome exercise of understanding this throughout the generations. I invite professors to share their comments on this, and we can take the discussion forward.
Thank you, Ankit. Thank you, Professor Neha, and for your paper and for this excellent presentation. I very much enjoyed reading your paper, and it was very different from the kind of theory that is outside, because as you rightly pointed out in your lecture and in your paper, the framework for addressing statelessness focuses on the technical causes of statelessness. And there isn't much talk on how states devise or come up with new covert ways of creating statelessness. So thank you very much for your work in this area. I also quite enjoyed how you've put together, this new diagnosis, as you call it in your paper, new diagnosis for statelessness, through 3 lenses. One is space, second time, and third administration. And often this, people talk about space, but there's a little bit of discussion on administration, but not a lot about time. And the problems that we have, especially in relation to the NRC in India and Assam, relates to this time element, as well as the administration element, as you point out in your paper. So I just have a few questions. I'll keep them short. So firstly, I was wondering about, given that, the 1961 Convention on the Reduction of Statelessness, which is the main convention or international law convention on addressing statelessness, focuses on these technical causes of statelessness. It talks about statelessness from a conflict of laws perspective, and also from a deprivation of nationality perspective. So I was wondering how this diagnosis would fit in with the overall international framework that exists right now. Do you think there should be an entire revamping of the system, or should it be, do you think there is scope for using international human rights law as it exists today with the Statelessness Convention to rework on how statelessness can be addressed? So that was my first question. My second question relates to the I Belong campaign, which you mentioned as well in your paper. And of course, I completely agree with you how the campaign only again focuses on the technical causes of statelessness, and a lot of these new causes of statelessness, which have arisen over time, have not been addressed. Combining that with, also the 2015 SDGs, the Sustainable Development Goals, and in point 16, which talks about the right to identity for all, where everyone should be issued documents. How this could also be exclusionary. It could create exclusion because again, it focuses on the formalities of inclusion rather than these aspects of inclusion that you mentioned in your paper. So how do you think these campaigns, the I Belong campaign with the Sustainable Development, should be restructured, incorporate these new causes of statelessness that you absolutely rightly pointed out in your paper?
Great, thank you. No, those are really great questions. So I don't think we should jettison the international law framework. I think the statelessness conventions form one cornerstone of it, because of course some statelessness, all the stuff that I don't talk about, is in fact because of technical problems. So there's a whole world of statelessness out there that I don't cover in the paper, because in fact the international law framework is much more adapted to tackle those instances of statelessness. So if you see the I Belong campaign, one of its main focus areas is to actually increase accessions to the conventions, the statelessness conventions, and they've seen a steady uptick in the past 10 years. And one of the positive impacts of that has been national statelessness determination procedures. So most states, in fact, don't have domestic procedures to try and figure out when someone is stateless. And one of the consequences of state accessions to the conventions has been an actual procedure at the domestic level that now the state needs to introduce to figure out if someone's stateless or not. The other positive impact has been a reduction in statelessness on account of gender discrimination. So again, this is a technical legal reform measure that some states have undertaken, where now, for instance, citizenship can be passed on through the mother, even in the absence of documentation dealing with the father and their identity. So there's been a few positive impacts of both the statelessness conventions and the technical legal reasons why statelessness is so widespread. I think what's missing is the fact that some of these technical legal measures can be counterproductive. So the emphasis on identity documentation, of course, it's an important one, depending on which state you happen to live in. So if you happen to live in a Western European state, which is where everything functions through the possession of an identity document, and there's no evidence necessarily of excluding a certain group of people, then there should, of course, be a push on you possessing this technical identity document, without which you cannot survive, you don't have mobility, et cetera, et cetera. I think what the recommendation misses is the fact that all kinds of identity documentation is a double-edged sword in a lot of parts of the world. And so India is, of course, one example, but it's the same issue in Uganda, it's the same issue in Kenya. So there's been a lot of pushback in Africa as well on the widespread nature of this identity documentation that is now being pushed by international NGOs and the UN together and the World Bank. So it's a technocratic solution to a problem, and the technocratic solution may really not be appropriate depending on the country and the political background. So I think what the paper is trying to push against is the fact of these abstract recommendations, such as states should really bolster their identity documentation drives without any consideration as to the local politics in different parts of the world. And so to the extent that we can get international law to not look at universal solutions that might work across the board, but more tailored solutions that are very specific to the country at hand, I think that would already be a step in the right direction.
Thank you, Professor. Thank you for that.
Yeah, let me come in here. Thank you, Professor Jain, for this talk and for the paper. It was a delightful read, and I've quite enjoyed it. I mean, discussing it the last couple of days as well. Firstly, I really appreciate how you have made the central rationale the fact that states use statelessness as statecraft and strategy to exclude people, or rather states always operationalize their nationality laws in these seemingly neutral ways, which eventually exclude a lot of persons. This is something that Andrea and I have been trying to argue as well, but we face some resistance from our colleagues who do formal, I would say, public international law, and they're usually not as comfortable with, something that we try to say, something which you do better, I think, to talk about the new international law of citizenship, borrowing from Peter Spiro, or even say that the rise or the advancement of international human rights law has led to some constraints on what states can do with their citizens. So I'd rather like the paper on those points as well. I'm gonna ask two questions at once. I have 4 questions in total for now. First was as you started with that, this is a new topic for you. So I wanted to ask you, how did you come across this topic, and what compelled you to write on this issue? And my second question was, and this is something I found rather fascinating at the beginning of the paper, and you said that statelessness once was an empowering as well as a disempowering status. It could be both once, and then after the world wars and with in the post-war era, it has only been this liminal space of vulnerability and nothing else. And when I read that, at that point, my thought was, oh, this sounds like, the empowered status sounds like more of a pirate. And then you eventually go on to talk about res nullius. That's something that I've seen Gary Simpson talk about in his scholarship on piracy and international law. But I did not find a mention of this connection between the status of a pirate and the so-called empowered status that statelessness could give someone. So I wanted to ask you this, and also to follow up on this question, I had one more, which is, other than these instances that you mentioned of people in mainland Europe trying to get themselves declared as stateless person other than enemy aliens, do you have any other instances in mind where individuals rather wanted such a status ascribed to themselves, that is the status of being stateless? So those are my first set of questions.
Great, thank you. This is all again really helpful. A lot of food for thought, and I continue to work on this. So the paper began actually talking to a colleague about his family history. So I have a colleague in the U.S. whose grandmom was denationalized and moved from Russia to the United States and showed up with no papers. So she wasn't a refugee. And he had all her documentation from like, years ago, et cetera, et cetera. And we were talking about how she was not a refugee, how she, it took, she couldn't even naturalize as an American citizen, and all the issues that, and so it was really a personal conversation about his family history. That then I started to think about the international law framework, and I was like, you know what? I have no idea actually, like, and then what happens to people like that now? Because so much of the focus is on refugee law. So I could have told him everything about refugee law. I could have told him everything about, naturalization criteria in the US. But I did not know what happens when you show up on a boat and you have nothing to show as to your previous origin, and you can't prove it. So it was just a purely, it was this wonderful family story that then set off this train of thought into what happens to people who have nowhere to go and who can't prove it, the fact that they have nowhere to go. And of course, I knew the politics of India at that point in time. Like I keep in touch with politics in India, even though I haven't been home for a while. So it was the two things coming together. It was the politics of India that I keep in touch with, and his very personal family anecdote coming together. So that's how the article was born. And in some way that also influenced the sorts of examples I draw on, that I've tried to have examples that draw on different parts of the globe and different kinds of situations of statelessness, because I didn't want it to be a conversation that's only, that's specific to South Asia or to Europe or to the North America, etc. And that actually, goes to some of your other two questions about the empowering status of statelessness. So actually I think this is not Western Europe, strictly speaking, it's much more sort of pan-Europe. So one of the main sorts of agents that was pushing for statelessness were the Russian Jews. So Russia, of course, being Eurasia, so it's also partly Asia. So the Russian Jews wanted to create like a specific category for themselves as the stateless, as part of a world community, a transnational world community of stateless people who would not be refugees, because that was not considered an empowering status. A refugee is someone who's at the mercy of the state, is asking for a favor. But the idea was that this is an identity that's beyond the nation state. And that should, and that it's had its own wishes and desires that go beyond the nation state at the form of political organization. So a lot of the push actually between the world wars came from Russian Jewry, which saw itself as a political organization beyond the nation state and did not want to be confined within this concept of citizenship and belonging or foreignness. So that again, one of the stories there is that this was exactly what was so threatening to the nation state, that if you have a transnational alliance which can compete with the nation state as a form of political organization, then that erodes the nation state's authority. And so, of course, that recognition never happened, notwithstanding fairly strong political movements to try and make it happen. But I think that might be true even today. Like, statelessness is an empowering status, only if it has a critical mass to some extent, rather than it being done on an individual basis. And then if the nation state perceives it as a threat, it tries to squash it. So it can be an empowering status only in very limited circumstances. And at least historically, I don't think we see that post the Second World War, let's say. And then finally, the analogy with pirates, like I would say what's different, and then so it's true that they're the res nullius going through, as a commonality going through the two statuses where you're in a liminal no man's land. Except, of course, for the pirate, that was a reason to say that then they become the enemy of humankind. Whereas for the stateless, the argument is not that they're the enemy of humankind, it's the fact they do not exist. So I wonder what is more disempowering, to not have you recognized at all, or to be thought of as, the worst thing that could happen to humankind, and therefore you're free game for anyone to attack. So it's so it's an interesting thought experiment as to what's worse, to not exist or to be the greatest enemy.
Absolutely. Thank you for those responses. And it's very nice to know about the jurisprudence in Russia, as you mentioned, about people wanting to be labeled as stateless. Now, something that you mentioned in your responses now was also the fact why I did not focus on a particular region, and which is something I think really wonderful about this paper, that it's such a good survey of different state practice. I'm going to shamelessly plug in our work again and say that this is what we've been trying to do since the start of this year, although in a different capacity. One of our projects looks at the determination of citizenship in India from a due process angle, where we've been seeing how the foreign tribunals in India function and if they fulfill the due process standards in international law. And for the same, we've come across some of these examples as well, but it's again very nice to know about examples from Thailand, two examples from Kenya, as well as some from Middle East as well. I had an expectation while reading the paper. So when you start talking about the time and space issue and eventually go to administrative practice, I was expecting that obviously Assam would, I think, feature administrative practice. I was also hoping Assam would perhaps feature, and as an example, in time and space as well, because there is a cutoff date of 24 March 1971, and there is a spatial limit as well, where we have a special law, Section 6A of the Citizenship Act, which applies only to Assam. And there's this now renewed political agenda in Assam since the start of this year, I think, to redo the NRC in the border districts, where they want to exclude 20% people. It's as clear as that. And there was a statement the day before as well. So they're very keen on redoing the NRC in the border districts. So I just had an expectation that perhaps could feature in the time and space sections as well. And one more, sort of slightly smaller expectation was that there are some Indian cases from the high courts which have looked into the status of stateless individuals and have gone on to read India's international obligations very liberally to guarantee these people some security of status. I think they sort of pale in comparison to obviously the Inter-American or the African coast decisions, but there has been some jurisprudence in India, which I thought could maybe fit into some of these arguments that you made about time and space, and about this other general helplessness that people feel when they are stateless, and when they, especially in a land where especially stateless refugees. And there is a case from Gujarat High Court about a child born to a surrogate mother whose parents were German citizens, and Germany would not give citizenship to the child. And then eventually Gujarat High Court goes ahead and guarantees Indian citizenship to this child. So those were my other interventions here.
And I'll respond very briefly. So this is the part of the paper that I think is the most incomplete in some ways. What do we do now? Like, now that we have all this problem, like, what do we do now? So the idea was to actually try and explore what a little bit as to what's happening at the national level. So not only India, like including in certain African courts, there's actually been quite progressive jurisprudence in little bits and parts. So it's again quite fact specific, usually, to the specific case of statelessness, for instance. But there have been some domestic court cases that have used fairly progressive legal principles to try and interpret the international legal obligation. So in this paper, like in the problem part, I stuck to mostly international law and regional supranational courts. But I think in the way forward, I want to try and see what national courts are doing, or national human rights bodies are doing, for that matter, not just courts, to try and put forward progressive interpretations in a way that could feed back into the international or the supranational level. So thank you. That's helpful to for the extra push to look at India as one of the examples of what might be happening at the domestic level. And then you're absolutely right. Like in a lot of these cases, in fact, like I group them according to the main feature of the case that I'm trying to highlight. But of course, it's intersectional, like a lot of times, because in most examples, it's 2 or 3 of these criteria that I talk about coming together and not just one. So the way I was trying to not confuse the reader also with the different fact situations was to try and use each case, so to speak, based on the dominant criteria that I think is exacerbating the problem of statelessness. But of course, in Assam, it's all 3. In the UAE, for that matter, I put it in time. But of course, it's also documentary practice. And so I think, again, in the latter part of the paper, I want to clarify that, usually states play also with the 3 different criteria. If one doesn't work, maybe they'll manipulate the other, or maybe they'll manipulate all 3, or maybe they'll be nested within each other the way you describe, where there's the NRC, but then for the border region, let's redo it even, So I think that's a helpful example of how, the nesting of the different kinds of exclusion as well. Thank you.
Right. Thank you very much. And I look forward to reading the paper in publication. Thank you.
Thank you, Ashish.
I think we lost Professor. Just in the interim, perhaps Professor Yadav wants to chip in, or if not, then now.
I think you should maybe. Okay. Sorry, maybe Andrea's back. Yeah. We couldn't hear you, Andrea.
Oh, can you hear me now? Okay. Thank you. Yes, so you mentioned, Professor, that you did not write this paper keeping one region in mind. You wanted to be sort of universal, which would apply in different circumstances and cases. But when I was reading this paper, and maybe this is because, again, as Ashish has mentioned, we've been focusing on the South Asian region. So when I was reading it, I found it very relevant as a theory for South Asia and also for statelessness in third world countries, simply because, whatever we have on statelessness,
the usual occurrence I can vouch for, because Professor teaches me, we usually find ourselves in a limbo where Professor is sorting out the computer. As the Yadav, would you like to continue this chain of thought? Perhaps you might have an understanding of this.
Yeah, well, I do. I can try. This relates to. I mean, I'll just I guess frame it in term of a question. I think. So there is a lot of obviously relevance of all this state practice for the South Asian region because of lack of formal legal obligations on this issue. So what my guess is that Andrea wanted to ask is that in this scholarship and in this area of law, do you think that there is perhaps some sort of emergence of a customary international law obligation on states which have not signed the statelessness conventions to naturalize stateless persons in their territory, or to perhaps, is there a larger obligation in your reading to not create statelessness, to not threaten the citizenship security of a state's own citizens? So do you think international human rights law or perhaps the conventions on statelessness have reached that stage?
Just before you come in, we had Professor Marty Koskinemi speaking to us a couple of days ago, and he spoke about the colonial project, and he emphasized the role of sovereignty and property. And he assessed that when the sovereign comes or when the colonial project starts, the main part of this project is to focus on property and have some sort of control on the property. And it's true. So perhaps you can look at it in that sense as well, that property thus becomes the essential breeding ground for the empire and for the crown to feed into the mercantilism project. We have Professor back with us, so we can perhaps have that chain of thought completed, and you can answer these collectively.
Yeah, thank you. I'm so sorry. I think my internet connection is very unstable. So yes, I don't know how much of my question you heard, so I'll just repeat it. I was explaining how your paper is very much suited for understanding statelessness from a third world perspective. And I was just wondering if was this part of your thought process, and do you think there is any merit in looking at the situation in third world countries, the statelessness situation, through the lenses that you're talking about, the three lenses that you're talking about? And do you think in the future there could be the shift from, looking at technical causes of statelessness to, looking at statelessness as a whole from time, space, and administration perspective? Because essentially, even conflict of laws or other causes of statelessness, I think, would fit in these, in these divisions that you've mentioned. That's what I wanted to ask. Thank you.
Great, thank you. So the paper was not sort of specifically directed, as you said, to third world explorations of statelessness. But as it happens, the most interesting work is happening in South Asia, Africa, and Latin America. So most of the examples that I give that are not from these three, or the Middle East for that matter, most of the examples that I give that are not from these regions are examples of state succession. So, which is the highly specific case, the Latvia case, for instance, the Slovenia case, those are all cases of state succession, which is where the European sort of scholarship and thinking about this is focused to a large extent. And so all these really creative ways of manipulating criteria are happening not in Europe for the most part now, like outside the case of state succession. And so I do think that actually some of the most interesting examples, and even sheer number of potential stateless, are much more interesting and much more relevant out from more of an African perspective, or a South Asian perspective, or a Latin American perspective. What I was hoping to do through this paper was also partly to bridge the gap that one sees in the scholarship more than anything else. I think there's some fantastic ethnographic accounts, for instance, in Asia, certainly in Africa, but they tend to be isolated from the legal accounts of citizenship and statelessness. There's some great historical accounts. So in European scholarship and American scholarship, you see these fields coming together much more often to try and create frameworks that might be applicable to law and to international law. In Asia, especially in South Asia, notwithstanding the absolutely incredible scholarship on these issues, the historians don't talk to the ethnographers, don't talk to the sociologists, don't talk to the lawyers. And no one talks to the political theorists. They're in their own world. So the hope was that this paper actually brings those areas of scholarship along with the NGO community to try and create something that would actually be helpful and actually be generative for the rest of the world, because those individual strands of scholarship are actually much more developed, I would say, in Africa or in Latin America or in South Asia. So I would be absolutely delighted if it happened to be the case that this paper was sort of one step in trying to generate that kind of scholarship that then becomes something that that's what the UNHCR should be drawing on when it talks about Since I Belong campaign, not some technocratic elitist top-down driven what do we do now. But this is that's the kind of bottom-up scholarship that the UNHCR should be looking at while it's designing what it thinks is the appropriate response to statelessness. So I'm hoping that maybe that movement will happen, especially because as you pointed out, and also as Ashish you pointed out, the more interesting jurisprudence is again from the regional courts. It's not from the third even. It's certainly not from the ICJ or someplace like that. It's really happening at the regional level, the most interesting jurisprudence. So this is something that needs to grow in some ways from the bottom up and try and inform what's happening internationally. Because, and this is to answer your question, Ashish, because I don't think there's a customary international obligation as such quite now, simply because there is a right to a nationality. And that's been there ever since the UDHR, but there's no right to a specific nationality. So you do have the right to be a national of somewhere, but who has to actually grant you that nationality is where international law backs off. And so that's where the push has to be. And then sure, I have a right, but if no one's going to give it to me, then there's no point in possessing a right that no one is the duty holder for. And so the real question is, how can we get the duty holder to actually be duty bound?
Thank you. There's a question which has been sent to me, so I'll just read it out. It is by Harshit Jain, and he asks, first of all, thanks you and offer his remarks. It says, I like how you connected statelessness and the nationality of Kuwait and political exchange of values. He asks his question, what are the obvious factors and how do we look forward to sort of a change to the dimensions so to attain real peace and justice and not think about issues at domestic levels, rather to look at major changes which may provide justice to statelessness and nationality issues. If you answer that, you get the Nobel Peace Prize.
Yeah, well, this is a question going all the way back to Kant, and if he couldn't answer it, then I can't answer it. So so that's also part of the challenge. No, but I think we live in a paradoxical world where nationality and the importance of the state was meant to be disappearing. There was all this talk about how nationality is not such a significant status anymore. We're all global citizens. We can all have 3 or 4 citizenships. Everyone can travel, and there's no barriers. Blah blah blah. Free movement. So I think the paradox is that there was a whole bunch of scholars, incidentally none of them from India or South Asia, claiming that nationality no longer matters because we're all global now. So I think what some of the answer to this has to be, well, much as we might want it or not want it, the nation state is still an overwhelming presence in the lives of very many people, especially people who don't happen to live in Western Europe. And so given the importance of the nation state, it would be great if we could supersede it, and there was actually a recipe for a global world justice project. But while the nation state continues to exist and exert this level of power over us, what can we first do to get the nation state to do what it was meant to do, which is guarantee us safety and security, and at least a little bit of welfare. But safety and security seem fairly basic. And so the idea is to first try and see whether we can work with the nation state, and then at some point maybe we do end up superseding it, but I doubt it will happen in my lifetime.
Perhaps in mine. Well, I just wanted to take this discussion back slightly into international jurisprudence, because under professors when I was interning, what became the bedrock of my reading is perhaps the foundation of the reading, and subsequent everything followed based on that was an article on the Nottingham case and the discussion on genuine link over there. And what I found there is that this is from an article which was shared, and it says that what emerges clearly from the judgment is that the genuine link requirement exerts only negative force. The acknowledgement of his long-standing and close connection with Guatemala does not entitle Nottingham to Guantanamo nationality. It only works to defeat Liechtenstein's claim over his nationality, because international law leaves it to each state to decide its rules on nationality. The presence of a genuine link can never confer nationality, yet its absence can negate it. The outcome of this asymmetry is that formal citizenship and a genuine link each become a necessary but rather insufficient condition for recognition of nationality. And this perhaps ties well with what you suggested as a positive obligation upon states and state manipulation. Dr. What are your comments on that?
Yeah, so Nottingham is one of those gifts that keeps on giving. Then people hate it or love it, but and then they disagree about what it actually says. But here's Mr. Nottingham, who's actually again trying very strategically to use his different nationalities or his different potential entitlements to citizenship, in a way that eventually doesn't work. But again, the basic point of the case is intended to be an empowering status. Again, I have a genuine link, and therefore, I can rely on the diplomatic protection of a particular state. But the court turns it into a question of, how do I demarcate between the different rights that states have over this individual, and how do I make sure that those don't come into conflict with each other? So the court is interested in maintaining the stability of the division of authority and sovereign authority between states, And when can one say that one state gets priority over the other when it comes to the right to exercise diplomatic protection, so as to exclude the other state from doing the same thing? And so in the paper, what I want to do is flip that way of looking at the relationship between the state and the individual, that you should not be concerned so much with this is what's in the state's interest and in the interest of maintaining the stability of the international order. It really is meant to be about the individual, that poor forgotten person in this case. It's really meant to be about the individual and what is owed to them, and not because there are different states fighting over, who gets to have the authority, but because no one wants to take responsibility for this individual. And sometimes that's deliberate. And so by not taking responsibility for this individual, you're also precluding another state from doing so. So it's almost the opposite of the not-a-bomb situation where potentially he could have claimed diplomatic protection from different states. And then there's the question about, which state. And here every state is saying, well, he's not mine. So, but I'm not actually going to say so. And so he can't go to anybody else either. And so in some way, it's the converse of the not-a-bomb situation, that how do we make sure that the lens from which the dilemma of this poor person is viewed does not become one of the stability of the international order, but becomes one of individual right.
Well, what if nationality stands as a sort of a barrier towards your sense of entitlement, or at least opportunity towards something? Like talk in the context of Olympic events, wherein our teams have, or there are separate teams all together representing stateless persons. So is that an empowering factor, or is it something quagmire of the 21st century and just based on principles of equity? It's just quite far away from what the topic is about, but I'm just generally curious to understand how this would be interpreted.
Yeah, and the nationality itself, of course, can be both empowering and disempowering. So again, I think the enemy aliens example, for example, you didn't want to be a national of a state because it was a highly disempowering status to be a national of Germany. You would rather be no one than a national of Germany. And so, in those cases, in the First World War cases, so there's no golden, there's no golden dust about nationality as such. In any given era, it will depend on the politics of nationality acquisition and then the entitlements that brings. And then there's a further question about, whether it's actually to your benefit to be the national of a state that then completely refuses to give you any protection, or would you rather be again a national of nowhere? So there's all sorts of questions about, why do we put so much into this box of nationality? Why do people sometimes want to buy their way into nationalities? So there's also the golden passports scheme, right? It's not just the Olympics. So it's the chutes and ladders, quite literally. That in some cases you want to fast track you're on fast track nationality and you want to acquire another nationality and maybe a third nationality because it entitles you to a whole list of things that your own nationality doesn't. But sometimes you would really rather not be a national. Or if you are a national, you only want to be one so you can claim refugee status elsewhere. So there's a whole spectrum of what nationality can mean in any given context.
And to this, I remember what Professor Popovski once shared with me. He said that at a certain point of time, everybody sought the European passport, perhaps the British passport, and now there is an influx of persons who are now seeking a European passport because simply because of the benefits which are attached to it, not really the opportunities per se. And you spoke about this with reference to a certain class of persons in mind who avail benefits, or more specifically tax benefits from the European passport as comparison to the Eastern European region, to Russia. So that was just a reflection that I wish to share. I do invite others to ask their questions and professors to share reflections upon the answers shared by Professor Jain. Yeah, professors, would you like to share any comments on the answers by Professor Jain?
I could just say that as Andrea had started her intervention with that fact that the diagnosis and the metrics on which the diagnosis is done is novel, and it was very refreshing to see that for us. And we do hope that the diagnosis leads to the cures, and not just in international policy. I mean, in many ways that Professor Jain suggested here, that there shall be tailor-made policies for each nation or for each situation, something which is, I think, quite ambitious, as has also been pointed out, and something which international law does not have the language for at the moment, maybe, as some would say. And I guess Professor Jain and we can follow in footsteps in finding those ways and arguing about those ways to perhaps advance this project of eliminating statelessness and contributing to this global project. Yeah, thank you.
Professor, thank you so much. It's been a riveting experience hearing from you. I invite you to please kindly share your final words, and then we can close.
Oh, well, thank you for bearing with me. Actually, it's not easy on Zoom. Everything is on Zoom. It's not easy to be online for hours on end, especially not on evening in India. So that's even harder. But thank you for again reflecting on the paper together with me. As I said, I do think the most interesting work is not being done in the West on these questions, but definitely in Asia and Latin America. So, I would very much welcome, any future thoughts, including on the specific case studies, because I think that's how we can actually try and make concrete recommendation. It's by drilling down into the very creative ways in which states use techniques. Otherwise, the state will always be one step ahead of us. So unless we do that kind of drilling down, thank you again for having me.
Thank you so much, Professor. It was truly awe-inspiring and thought-provoking discussion. And thank you for joining this series and for being a part of this discussion. We would very much appreciate if we stay in touch. We'd like to invite you to campus next time around for the physical lecture. And then the paper is finally published. You can all have a copy of it as well. Thank you so much for being with us, Professor.
Great, thank you. Have a good evening, everyone. Thanks again.
Thank you so much. Thank you. Thank you, everyone else, for joining this discussion. We will return next week yet again, another Rhodes Scholar, as Professor Jain is. We'll have Professor Alan Hendrickson, who's a former teacher of mine. He's going to speak about public diplomacy in the 21st century. Thank you, Professor Jain. We are honored to have you amongst us, and we wish you good health and relaxing weekend. Thank you so much.
Thank you.